Welcome. NOIS welcomes you all in this educational video for subject Political Science. Code here 317. This is for senior secondary level. Today's topic is Supreme Court of India. Part 1. First, we will discuss about difficult words. Court. Collegium. Original jurisdiction. Appellate jurisdiction. Court of record. Protection. Guardian of the Constitution. Civil cases and criminal cases. Judicial review. Public interest litigation. Judicial activism. Objectives. Recognize that India has a single, integrated, and unified judicial system. Describe the composition and organization of the Supreme Court of India. Explain the power and jurisdiction of the Supreme Court of India. Appreciate the role of the Supreme Court of India as guardian of the Constitution and protector of fundamental rights. Recall that public interest litigation plays an important role in the protection of our rights. Now, single unified and integrated judicial system. The Supreme Court stands at the top of the single integrated judicial system with High Court at the state level. Below the High Court, there are several subordinate courts such as the District Court, which deal with civil cases, and the Sessions Court, which decide criminal cases. Indian judicial system. Supreme Court of India, state high courts, subordinate courts or lower courts. Supreme Court. The Supreme Court is the highest judicial authority of India. It consists of the Chief Justice and 25 other judges. The Parliament may increase the number of judges if it deems necessary. Beside the Chief Justice, there were only 7 other judges. The Parliament has increased the number of judges from time to time. As in 2005, there are 25 judges besides the Chief Justice, who is also called the Chief Justice of India. The Chief Justice and other judges of the Supreme Court are appointed by the President of India. While appointing the Chief Justice, the President is constitutionally required to consult such other judges of the Supreme Court as he deems proper, but outgoing Chief Justice is always consulted. Normally, the senior most judge of the Supreme Court is appointed as the Chief Justice of India, although there is no constitutional requirement to do so. While appointing other judges, the President is bound to consult the Chief Justice and other senior judges if he deems proper. Whenever there is vacancy or likely vacancy in the Supreme Court, the Chief Justice and 4 other senior most judges consider various names and recommend the name of the person to be appointed as judge of the Supreme Court. This system is based on ruling of the Constitutional Bench of a Supreme Court headed down in 1993 and reinforced in 1999. Thus, while the Constitution still provides that the President is the appointing authority of the Supreme Court judges, the ruling of the Supreme Court has since 1999 become virtually binding on the President. The power of selection of judges has passed on to a group of Supreme Court judges called the Collegium of the Court. The President now performs the formality of appointing the nominee of the Supreme Court. After the law, Ministry formally recommends those names to him. Break.
जीवन ये प्रकाशित करने राहों को आलोकित करने, जीवन ये प्रकाशित करने राहों को आलोकित करने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने, अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने, जीवन ये प्रकाशित करने राहों को आलोकित करने। धन साधन समय की सीमा से विद्यालय जो मुक्त हो, धन साधन समय की सीमा से विद्यालय जो मुक्त हो, कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो, कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो, मित्रों हम उठे और जागे, मंजिल आने की ध्वनि सुने, हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं ज्ञान ये प्रकाशित करने, राहों को आलोकित करने।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर दुनिया में इसके केंद्र बात कोई मन चाहा केंद्र चुने, अपना जीवन स्वयं बने, हम अपना रास्ता स्वयं चुने, कोई मन चाहा केंद्र चुने, स्वयं बने हम।
Qualifications. A person is qualified for appointed as a judge only if he or she is citizen of India and if he or she fulfill one of the following condition. A. He or she has been for at least 5 years a judge of as High Court or two more than two such courts. Or he or she has been for at least 10 years an advocate of a high court or two of more than two such courts. He or she is the opinion of the Parliament, a distinguished jurist. Time tenure. The Chief Justice of India and other judges of the Supreme Court hold office till they attain the age of 65 years. And a judge may voluntarily resign before expiry of his term. In exceptional cases, a Supreme Court judge may be removed before the age of retirement, according to the procedure laid down in the Constitution. Removal. A judge of the Supreme Court can be removed from office by an order of the President, passed after an address by each House of Parliament, supported by a majority of total membership of the House and not less than 2/3 majority of the members of the House present and voting passed in the same session has been presented to the President for such removals on the ground of proved misbehavior or capacity. So far, proceedings for removal were initiated only in one case against a judge of the Supreme Court, but he or she could not be removed because the resolution could not be passed by the Parliament. It is clear that Supreme Court judges enjoy security of tenure and the executive cannot arbitrarily remove them. No person who has held office of a judge of the Supreme Court is allowed to be peeled as an advocate in any court or before any authority within the territory of India. Supreme Court judge cannot be a lawyer for anyone. The judges of Supreme Court are paid such salaries as are determined by the Parliament for time to time. Court of Record. The Supreme Court is a court of record. It has two implications. All its decisions and judgments are cited as precedents in all courts of the country. They all have the face of law and are binding on all lower courts and indeed the high courts. As a court of record, the Supreme Court can even send a person to jail who may have committed contempt of the court. Jurisdiction of the Supreme Court. The scope of power of Supreme Court to hear and decide cases is called its jurisdiction. The Supreme Court has three types of jurisdictions, namely original, appellate and advisory. Original jurisdiction. There are certain cases which falls within the exclusive jurisdictions of Supreme Court. It means that all such cases being or originated in the Supreme Court only. It also means that such case cannot be initiated in any other court. The case of dispute that come under the original jurisdiction are given below. Point first A. Dispute between the Government of India on the one side and on or more state on the other side. B. Disputes between the Government of India and one or more state on one side and one or more state on the other side. Disputes between two or more states. The Supreme Court has been invested with special powers in the enforcement of fundamental rights. In this connection, it has the power to issue directions of writs. Cases under public interests litigations PIL can also be heard directly. This is an extra constitutional practice. There is no mention of PIL in the Constitution. Break.
जीवन ये प्रकाशित करने राहों को आलोकित करने
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने हम अपना रास्ता स्वयं चुने अपना दीपक स्वयं बने हम अपना रास्ता स्वयं चुने जीवन ये प्रकाशित करने राहों को आलोकित करने
धन साधन समय की सीमा से विद्यालय जो मुक्त हो धन साधन समय की सीमा से विद्यालय जो मुक्त हो
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो
कभी पढ़े हम कहीं पढ़े वे विषय की लोच से युक्त हो
ज्ञान ये प्रकाशित करने, राहों को आलोकित करने।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर दुनिया में इसके केंद्र बहुत, कोई मन चाहा केंद्र चुने, हम अपना जीत स्वयं बने, हम अपना रास्ता स्वयं चुने, कोई मन चाहा केंद्र चुने, स्वयं बने हम।
Appellated jurisdiction. The power of a superior or higher court to hear and decide appeals against the judgment of a lower court is called appellate jurisdiction. The Supreme Court has vast appellate jurisdiction. It hears appeals against the judgment of the high courts. It is the highest and the final court of appeal. If one of the parties to a dispute is not satisfied with the decision of the High Court, one can go to the Supreme Court and file an appeal. The appeals can be filed in civil, criminal, and constitutional cases. Appeals in civil cases, disputes relating to property, marriage, money, contract and service, etc., are called civil cases. If a civil case involved a substantial point of law of public importance in needing interpretation of the Constitution or law, an appeal against the High Court decision can be made to Supreme Court. Earlier, The financial limit of such civil cases was rupees 20,000, but now, according to the 30th Amendment of 1972, there is no minimum amount for taking a civil appeal to the Supreme Court. If substantial question of interpretation of law or constitution is involved, appeal may be made against the decision of the High Court. Appeals in criminal cases. An appeal may be brought to the Supreme Court against a High Court decision in a criminal case in a number of situations. Firstly, if a High Court sets aside an appeal or an order of acquittal passed by a lawyer court and award that sentence to the accused, he may bring an appeal to the Supreme Court by rights. Appeals in criminal cases. Secondly, appeal can also be made to the Supreme Court if the High Court withdraws a case from a lower court to itself, declares the accused guilty and awards that sentence. For example, Nirbhaya case in Delhi. In this situation, also appeals can be made as a matter of right and without certificate from the High Court. The appeal in cases other than those two categories may also be brought to the Supreme Court. Cases related to violation of fundamental rights and PIL can be directly appealed in Supreme Court or High Court. Court provides provided the High Court grants a certificate that the case is fit for appeal to Supreme Court. Appeals in constitutional cases. A constitutional case is neither a civil dispute nor concerning a crime. Case related to writs which involves violation of fundamental rights, for example, Keshav Nanda Bharti case, where a basic structure of constitution cannot be changed was defined. It is a case arising out of different interpretation of constitution, mainly regarding the fundamental rights. In such constitutional cases, an appeal can be taken to the Supreme Court only if High Court certifies that the matter in dispute involves a substantial question of law. If the High Court denies a certificate of fitness to appeal to the Supreme Court, the Supreme Court can use its discretion and grant special leave to appeal to itself in any case it deems fit. Advisory jurisdiction. This power implies courts' right to give advice if sought. Under advisory jurisdictions, the President of India may refer any question of law or public importance to Supreme Court for its advice. But the Supreme Court is not bound to give advice. In case the advice or the opinion of the Supreme Court is sent to the President, he may or may not accept it. The advice of the court is not binding on the President. So far, whenever the court has given its advice, the President has always accepted it. The court refused to give its advice on the questions whether a temple existed at the spot where Babri Masjid was built at Ayodhya. So far we understand part 1. Thank you.